What are we doing on this case?
Now we're asking for a preliminary exam.
Before the judge even finishes that first line, you can already feel the tone of this courtroom session. These opening seconds might seem routine, but they set the stage for something that happens in courtrooms every single day. Procedural decisions that quietly shape the entire direction of a case. What we're looking at here is the early phase of a criminal process, where attorneys and the judge are clarifying what stage the case is in and what happens next. Now, the key phrase you're about to hear is preliminary examination. That's a crucial step in many criminal cases. A preliminary exam isn't a trial, it's more like a legal checkpoint. The prosecution has to show that there's enough evidence to justify moving the case forward to trial. Think of it as the judge asking, is there probable cause that a crime occurred and that this defendant may have committed it? And here's why that matters. If the prosecution can't establish that foundation, the case could actually be dismissed right here. But if they do meet that threshold, the case moves forward and the stakes suddenly become much higher for everyone involved. As we move through this hearing, keep an eye on how quickly the conversation shifts from scheduling and procedure into something more serious. Allegations of contact with the victim, bond conditions, and questions about what the defendant may or may not have done. Courtroom hearings often start quietly like this, and then suddenly turn into moments where credibility, evidence, and the judge's patience are all put to the test.
So your discovery is complete?
That is my understanding. We do have the police report, and I do believe it was median, and we have that as well.
All right. People have their witnesses available the 24th. Preliminary examination in person, February 24th, 2026 at 9 a.m. before Judge Barr. And as to bond in this case, my understanding, go ahead, Ms.
Your Honor, it came to my attention that the defendant has made 12 calls to the listed number from the victim from other pins. We confirm that this is her number. As I also stumbled upon a text to the victim as well. So this time I'm going to be asking for a phone number. This text privileges to be revoked.
All right. Any response?
Well, can I say something? I haven't made no text. She had texted me from a number and I didn't block it. Yeah, I didn't never text her.
He's saying that he is not text.
Pardon?
I haven't texted her. But it was a text that she had sent and I ended up blocking it. I never said nothing to her.
This moment right here is where things start getting interesting from a legal perspective. The defendant is pushing back against an allegation that he contacted the victim, specifically through calls and possibly texts. In many cases involving alleged victims, courts will impose strict no-contact conditions as part of the defendant's bond. That means no calls, no messages, no indirect contact, nothing. And here's why courts take this so seriously. The purpose of bond conditions is to protect the alleged victim and preserve the integrity of the case. If a defendant violates those conditions, even unintentionally, it can result in bond revocation, meaning they could be taken back into custody while the case proceeds. Notice how the judge responds here. Instead of immediately accusing the defendant of lying or escalating the situation, the judge takes a more measured approach. He essentially says, if you truly didn't text the victim, then revoking phone and texting privileges shouldn't be an issue. That's a subtle but powerful judicial move. It removes the opportunity for further contact while also sidestepping the need to prove right now who is telling the truth. This is a classic courtroom balancing act, protecting the alleged victim while keeping the process fair to the defendant. But it also raises an important question for viewers. Do you think the judge handled that fairly, or should the court have investigated the alleged contact more aggressively right away?
Well, here's what I'm going to do. Do not test here. There won't be an issue, I don't think. But what I'm going to do is I'll continue his bond. But at this point, I'm going to revoke his phone and texting privileges. All right. Take a closer look at it. All right. Thank you. Amber Estelle.
Your Honor, on behalf of Mrs. Estelle, please approach you. Mrs. Estelle, state your name for the record.
Amber Estelle.
Estelle. Judge, we're asking for an adjournment. Ms. Estelle is hoping to get accepted into the treatment court in Hillsdale County. So if she's able to get into there, we'd like to see if we could attach this case to that. When is your next court date?
You've seen the progress report?
I did, Your Honor. Yes, I have my notes for that. We did review it. I've spoken with her. She states that she spoke with Ms. Dozier last night. I think this came in earlier in the day yesterday. She has completed her intake with Hillsdale County. She's since taken 3 tests. They informed Ms. Dozier that they're supposed to be sending the results over to our community corrections.
She has since when taken 3 tests?
From, what is it, the February the 5th date? Is that when did you do the intake?
Last intake for Hillsdale County or here?
For Hillsdale.
Yes, it would have been Thursday. So Thursday, Friday, and then yesterday.
You
were on my
tested-
screens, yeah.
She says she's tested 3 times with Hillsdale County and they're supposed to be sending the results.
And
over.
what, we don't know the results of that?
She says that they're negative, except
Says
for
they're negative.
she does, but I don't have the results, obviously. She said that they've supposed to send it to Ms. Dozier. So if we can maybe pass, I can reach out to Ms. Dozier to see if she's received them.
And those are supposed to be all negative.
She says negative, except for Suboxone, which she has a prescription for.
And THC, because that takes more than 30 days to get out of your system.
This section shifts the focus from alleged contact violations to something equally important in many criminal cases: substance use and compliance with bond conditions. The defendant explains that THC appeared in her system because it can remain detectable for weeks after use. And scientifically speaking, that's actually true. THC can linger in the body far longer than many other substances, sometimes several weeks depending on frequency of use. But here's the legal complication. Even in states where marijuana is legal, that doesn't automatically mean someone on bond is allowed to use it. Courts often impose stricter conditions than everyday law allows. Judges can require defendants to remain completely substance-free while awaiting trial, regardless of whether a substance is legal in the state. You also heard the judge question whether the defendant has a medical marijuana card. That's significant because medical authorization could potentially justify THC in a drug screen. Without it, however, the presence of THC could still count as a violation of bond conditions depending on how the judge interprets the rules.
I've only been released for like a week.
Do you have a medical marijuana card?
No,
Are you still smoking marijuana?
no, but this would have been from prior because it takes like 3 to 4 weeks to get out of your system.
Right, but prior you didn't have a medical marijuana card either.
No, but it's illegal
Really?
in the state of Michigan.
Yeah, I'm shocked.
Okay.
Is that right? It's legal?
Yes,
Yeah.
yes, Judge, but she does understand while under bond conditions, she is not allowed to use any substance unless they have been prescribed.
But she has other cases pending outside of this one. And do those cases let her use THC?
No, Your Honor.
No?
I'd have to look at the
So
dates.
you've been on those cases for more than 30 days?
I have to
No,
look at the
sir.
dates, Your
No?
Honor.
No, sir, I got out on bond in Hillsdale County and got sent here and then got out on bond here and started my Hillsdale County. It was all within, it's only been 2 weeks.
All your charges have been 2 weeks
Yes, sir.
for the time of arraignment.
Yes, sir.
Are you just unlucky?
She's,
She may.
let me get my computer too, Judge.
Okay, you go ahead and do that. Yeah, tell them marijuana is legal. Didn't know that. I'm kidding.
Next thing you'll tell me is sports gambling.
I just learned that they call those parlays, Judge. It's a new word.
Why are you gambling on sport?
I don't.
Okay, why are you
I don't have
parlaying?
I just learned the phrase, and I hear it's a bad thing.
So why are you hanging around people that are parlaying?
You know.
I'm not saying they're not respectable. I just want.
I'm trying to be a good influence on people.
You're trying to what?
Be a good influence.
You are?
That's right.
Okay. As opposed to what you've done in the past, right?
That's
okay.
Right. Hope for everybody to change.
Still waiting.
If you're listening closely, this exchange between the judge and the people in the courtroom is doing something interesting. It's blending humor with a subtle message about accountability. Judges sometimes use moments like this to ease tension, but they're also reinforcing an important idea. The court expects change from defendants who appear before it repeatedly. When the judge jokes about gambling parlays and then says he's trying to be a good influence, it might sound lighthearted, but there's a deeper layer. Courtrooms see many of the same individuals multiple times across different cases, and judges often become very familiar with patterns of behavior. That's why you hear the line about hope for everybody to change. It's a reminder that the justice system is not only about punishment, it's also about rehabilitation. But rehabilitation only works if defendants actually follow the conditions placed on them. And that's why the conversation about drug tests and compliance becomes so critical. Judges want to see progress, proof that someone is taking steps to correct past behavior. Moments like this also humanize the courtroom. It's not just legal arguments and rulings, it's real people, sometimes trying to turn their lives around, sometimes struggling to do so. So here's a question worth considering. Do moments like this make the courtroom feel fairer and more human, or do you think humor has no place in serious legal proceedings?
I'll just receive drug test results from Hillsdale District dated 2/5/2026 with a positive result for amphetamines, fentanyl, THC, methamphetamines. 2/6/2026 THC prescribed buprenorphine, 2/11/2026 THC prescribed buprenorphine. That was faxed yesterday in this document.
So her next one didn't show fentanyl.
Right. Yeah, the first one showed fentanyl, amphetamines, THC, and methamphetamines. On February 6th, the next day was a THC and buprenorphine, which Ms. Dozier notes prescribed buprenorphine. And the same on 2/11 THC and prescribed buprenorphine.
Got it.
Now we reach a pivotal moment in the hearing. The actual drug test results are revealed. And these results dramatically change the tone of the conversation. The first test shows fentanyl, amphetamines, methamphetamines, and THC, which are extremely serious findings. Fentanyl alone is one of the most dangerous substances courts encounter today, and the presence of multiple substances can raise immediate red flags for judges. But then something interesting happens. The subsequent tests show improvement: THC and prescribed buprenorphine, which is often used in treatment programs for opioid dependency. That shift is important. It suggests that whatever happened in the first test may not represent the defendant's current behavior. Judges often look at patterns rather than isolated incidents. If someone tests positive repeatedly, it signals ongoing use. But if later tests show negative results or only prescribed medication, it may indicate the person is trying to stabilize. That context likely plays a role in the judge's decision shortly after this moment. Courts often weigh risk versus progress, asking whether the defendant is improving enough to justify continuing bond instead of revoking it.
He just didn't know. Sometimes you're not good, you're just lucky. All right. So you wanted adjournment?
Yes, Your Honor.
Grant the adjournment.
Thank you, Judge.
Probable cause will be adjourned March 5th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor. That's March the 6th, right?
What did I just say? Do you have a calendar? Yeah, look, squint.
You're right. You're right. Yep.
No, I know I'm right. I'm just saying you're not.
It's not the 6th, March the 5th. Fine.
Thank you.
Judge. I'm sorry.
Good afternoon, Your Honor. Edward Lucas on behalf of Craig Ivey. Craig Ivey.
Thank you.
Okay, there's a lot of discovery that just came in. I'm looking to review that with him and Just asking for a brief adjournment.
March 5th, 2026, 9 a.m.
Thank you, Your Honor.
Bond continue. One, there's a violation. Okay. Did you get notification of a violation report?
There was something that was mailed to me. It was regarding a medical card that he needs to provide that as soon as he has the physical card.
Medical marijuana card?
Yep.
Do you have it?
It's in the mail, waiting for it to come.
It's in the mail.
Yeah, like I haven't got it yet.
Sounds like checks in the mail, but this is something.
The card's in the mail?
Yeah.
From where?
My doctor, I talked to my doctor and he told me he was going to mail it, and I've been waiting for it from the agency. I haven't.
Your doctor mailed it? Didn't come from the state?
I'm assuming it's coming from the state, but I haven't got it yet. I'm waiting for it consistently. I've been checking every day in the mail for it.
But they went through this the last time. Was that not you?
Might have been somebody else.
Yeah, it was somebody else. You didn't know.
You getting it? Okay. When's the last time you had a card?
I had my card originally. The last time I had my physical copy was when I got arrested in September. Guys, they had took it with my evidence, my phone. I have not got it back.
So they took your card?
Yeah. And I actually put in an order for a new one, which is what I'm waiting for currently right now.
So here's the problem. You told them on 2 occasions that it's in the mail and that you're still waiting for it.
Correct.
Something tells me that's not true.
It actually is. But
so why? So, okay. I realize our postal service isn't the greatest, but this is now going on a month.
I understand.
Okay, I'm going to ask you directly.
Yeah.
This exchange is one of the most intense parts of the hearing because it revolves around something courts value above almost everything else: credibility. The issue here isn't just the medical marijuana card. It's whether the defendant has been truthful about it. The judge begins questioning the timeline. When the doctor supposedly mailed the card, when the state processed it, and when the defendant told community corrections that it was already in the mail. These details might seem small, but they matter a lot in court. If a judge believes someone is being dishonest, that perception can affect every future decision about bond, sentencing, and credibility in the case. Notice how the judge gives the defendant an opportunity to step back and speak with his attorney before continuing. That's not just courtesy. It's a strategic judicial move. Judges sometimes do this to allow defendants to reconsider statements before the situation escalates into a formal finding of dishonesty or violation, and the judge's warning is clear. If the story doesn't change and the timeline doesn't make sense, consequences could follow. At this moment, viewers might ask themselves, is the defendant genuinely confused about the process, or is the judge catching a story that doesn't quite add up?
Is that card on its way?
Yes.
Where's it coming from?
It's coming from the state, I believe.
Then what's your doctor have to do with it?
He was the person I went through that ordered it for me, issued it for me.
He ordered it for you?
Yes.
When did that happen?
That happened at the end of January. So I'd say
Say what?
January 28th. I actually talked to him and had him issued it. So
That doesn't fit with what this is with community corrections, because he wouldn't have told you it's in the mail prior to the 28th.
that's what he told me it should be.
Is this a story you're going to stick to?
Yes.
Because this is going to be a long day for both of us if this is a story you're sticking to. So what I'm going to do, what I'm going to do is I'm going to give you a chance. I'm going to let you sit down, talk with your attorney. I'll call you up momentarily and let me know if that's the same story you want to stick to. If that's the same story you want to stick to, then I got to do what I got to do.
Thank you, Your Honor.
I'll pass it along. Thank you.
Thank you.
Yes.
Good afternoon, Your Honor.
Good afternoon.
So we had an opportunity to discuss what we talked about.
Mm-hmm.
And Drukas called the doctor, and the doctor said on January 31st, it was mailed to the state. He provided me with a number to the state. I contacted them. They did receive it on. It was 2 days ago they received it, and he should be getting a card as soon as that gets processed. So he should be.
So he didn't lie to me today. He lied to community corrections at 2 times before that.
What that order particular says is that it doesn't give a time frame on when he told them that it was in the mail. So if he told them twice.
Yeah, but the doctor didn't mail it out on the 31st, till the 31st, so he didn't know that.
Well, he didn't. He's tested since then, and he's was asked in person at least one time.
I give you your adjournment to the 5th.
Thank you, Your Honor.
We'll find a violation at this point. Thank you.
Thank you.
Continue.
With that final ruling, the judge effectively decides how this situation will move forward. And it's a decision that reflects the balancing act courts face every day. The judge grants the adjournment and chooses not to find a bond violation at this time, despite the earlier concerns about the marijuana card and the timeline inconsistencies. That decision suggests the court believes there's at least enough explanation or uncertainty to justify giving the defendant another opportunity rather than imposing immediate penalties. Courts often prefer to allow cases to proceed with additional information rather than rushing into punitive action when facts are still being clarified. The new court date means the case will continue. Yidik and the judge will likely expect clearer documentation by then, especially regarding the medical marijuana authorization and compliance with bond conditions. If those documents appear and everything checks out, the defendant may avoid further issues. If not, the court could revisit the possibility of violations. Cases like this highlight how courtroom decisions aren't always black and white. Judges must weigh evidence, credibility, public safety, and fairness all at once. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.